One court, 9 states, 65 million Americans, and a 132-year streak so statistically impossible that no mathematician would call it coincidence. They would call it a fixed result. The Second Amendment Foundation just filed a 47-page legal document so explosive, so precise, so devastating in its documented evidence that legal analysts are calling it the most aggressive brief ever filed against a sitting federal court in American history. And what is inside this document is going to make you furious, because this is not a story about one bad ruling. This is a story about 132 years of coordinated constitutional warfare against your Second Amendment rights. And as of April 2026, that warfare may finally be coming to an end. This is Firearms Law Advisor. Let's break down every word of what was just filed. Before we go any further, if you believe the Second Amendment deserves a real voice, subscribe to Firearms Law Advisor right now and turn on every single notification. When the Ninth Circuit responds to this brief, when SCOTUS moves, when Congress acts, you need to know within minutes. Hit that subscribe button, hit that bell, and after you subscribe, drop Firearms Law Advisor in the comments right now. I personally go through every single comment and I will find yours and thank you directly. Let's get into what was just filed. Let's start with a number that should stop you completely cold. Since 1891, that is 132 years of federal court history, the Ninth Circuit Court of Appeals has allowed exactly one Second Amendment victory to stand. One in over a century, covering 9 states, covering 65 million American citizens. And that single victory only survived because California's Attorney General office forgot to file their appeal paperwork on time. It was not justice. It was a clerical error. Think about that mathematically. Flip a coin 132 times. The odds of it landing on the same side every single time, except once, are so astronomically small that no statistician would call it chance. They would call it a fixed result. Every magazine ban challenge reversed. Every carry restriction challenge reversed. Every assault weapon ban challenge reversed. Every gun rights victory at the 3-judge panel level crushed by en banc review. 100%. No exceptions. No variation. No explanation that survives mathematical scrutiny. Drop your answer in the comments right now. Do you believe a court can rule against gun rights 100% of the time for 132 years by pure coincidence? Type bias if you think this is deliberate, or type coincidence if you somehow believe this is random. I want to see exactly where this audience stands. Here is the mechanism, and once you understand it, you will never look at the federal courts the same way again. En banc review is supposed to be rare, reserved for genuinely exceptional cases, major unresolved legal questions, direct conflicts with Supreme Court precedent. The Ninth Circuit grants en banc review in less than 2% of all cases. But here is what the brief documents with cold precision. When gun rights organizations win at the 3-judge panel level, the Ninth Circuit grants en banc review 100% of the time. Every single win gets pulled back in front of the full court, and every single time, that full court reverses the decision. Here is the other side of that equation. When gun control laws are upheld by a 3-judge panel, how often does the Ninth Circuit grant en banc review to reconsider? 0. Never. Not once. Apparently, those 3 judges got it right. The en banc process has been converted into a precision instrument. In Second Amendment cases, it exists for one purpose only: to destroy victories that gun rights organizations have legitimately earned in court. And this is not just legal warfare, it is financial warfare. Nonprofit gun rights organizations operate on limited budgets built from individual donations. State governments have unlimited taxpayer funding. A standard federal appeals case runs $50,000 to $200,000 in legal fees. When en banc review is forced, that cost triples. California spent over $15 million in a single year defending gun laws that panels had already called unconstitutional. The Second Amendment Foundation's entire national budget runs under $5 million annually. The brief calls this exactly what it is: systematic abuse of procedural tools to achieve political ends through financial attrition. Answer this in comments. Should federal courts be permitted to use procedural mechanisms as financial weapons against constitutional advocacy organizations? Type misconduct if you believe this crosses a line, or type legal if you think courts have unlimited procedural authority. Drop it right now. Let me tell you about the specific case that finally pushed this brief into existence. Woolford versus Lopez, a challenge to Hawaii's gun registration system, filed and argued through April 2026. Here is how Hawaii's system works. You pass a federal background check, the FBI's NICS system, examining your complete criminal history, mental health records, and domestic violence records. You legally purchase from a federally licensed dealer. The federal government has determined you are not a prohibited person, but Hawaii says not so fast. You must now register that firearm with the state and physically bring it to a police station for inspection before you are legally permitted to possess it in your own home. A 3-judge Ninth Circuit panel struck this down unanimously. All 3 judges, including judges appointed by Democratic presidents, agreed that Hawaii's system was historically unprecedented and facially unconstitutional. Hawaii's attorneys could not cite a single founding-era law requiring citizens to bring firearms to government officials for inspection. Not one historical precedent existed. The record was completely empty. So what did Hawaii do? They petitioned for en banc review, and the Ninth Circuit accepted that petition within 48 hours. The average time for en banc acceptance in other constitutional cases across the federal system is approximately 8 months. For this Second Amendment case, 2 days. That is when the Second Amendment Foundation filed their brief, not just a legal document, a constitutional indictment. Have you ever heard of any federal court accepting en banc review in 48 hours in a case the state just lost? Type "never heard of it" or "this is normal" in the comments. I want to see how informed this audience is on judicial procedure. This brief does not simply ask the Ninth Circuit to reconsider its position. It has moved far beyond that. The brief documents 3 categories of evidence. First, timeline data showing en banc petitions from gun control states in Second Amendment cases average 23 days to acceptance at the Ninth Circuit. In other constitutional areas, 8 months. That gap is not random variation. That is a documented systematic pattern. Second, public statements from a Ninth Circuit judge writing on the record that the court would interpret Bruin as narrowly as possible to minimize its impact on gun control laws. A federal judge publicly announcing intent to minimize the impact of a binding Supreme Court decision is not judicial independence. That is open defiance of constitutional authority. Third, a formal request for disclosure of all communications between Ninth Circuit judges and state attorneys general offices, because the pattern is so consistent and so mathematically improbable that the brief argues the only coherent explanation is active ongoing coordination. 3 specific demands. The Ninth Circuit must withdraw en banc review and reinstate the panel ruling. If it refuses, the brief establishes full grounds for emergency Supreme Court supervisory intervention, a remedy invoked only twice in American history, once during the Civil Rights era when Southern courts systematically refused to enforce desegregation, and once when lower courts were rubber-stamping police misconduct. Third, a congressional investigation, including subpoenas for judge-government communications and sworn testimony before House and Senate Judiciary Committees. Your prediction. Type "SCOTUS intervene" if you believe Supreme Court supervisory intervention is necessary, or "let it play out" if you think the system resolves this internally. Drop it in the comments right now. Here is what you just witnessed: a 47-page constitutional indictment against an entire federal court, a 132-year, 100% reversal rate on gun rights victories, en banc review weaponized exclusively against gun owners, a 48-hour acceptance on the Woolford petition while other constitutional cases wait 8 months, a federal judge publicly stating intent to defy Supreme Court precedent, a 90% SCOTUS reversal rate when cases escape the circuit, meaning 9 out of 10 times the Supreme Court reviews a Ninth Circuit gun ruling, they overturn it, and a formal request for the most extreme judicial remedy in American legal history. This is not routine legal news. This is a constitutional confrontation that will define gun rights in the Western United States for the next generation. California, Oregon, Washington, Arizona, Nevada, Idaho, Montana, Alaska, and Hawaii. Every gun control law upheld by a court, now under formal documented challenge for systematic bias, becomes legally vulnerable. Magazine bans, assault weapon bans, carry restrictions, ammunition regulations, all of it. Here is what you do right now. First, subscribe to Firearms Law Advisor and hit that notification bell immediately. When the Ninth Circuit responds, when SCOTUS moves, when Congress acts, you will know within minutes. Second, smash that like button and share this video with every gun owner you know in a Ninth Circuit state. Most of them have no idea this brief was filed. Third, drop Firearms Law Advisor in the comments right now.